4, 3, 2, 1.
Hello and good morning to my beloved lecturers separtiban anak lelaki Monggona Sundaram and my fellow friends. Today, we will present about company law on chapter 7, which is winding up for the company. First of all, let me introduce the players in this presentation. First, we have first player, which is me, Nur Farisha Elina binti Jamaluddin, and my metric number is 01 DAT 20F1019. Then, we have second player, which is Nur Akmal Serina binti Muhammad Azmi. Her metric number is 01 DAT 20F1029. And last but not least, we have Nur Shafiza binti Jamluddin, and her metric number is 01 DAT 20F1033. Hello, I am Nur Farisha Elina binti Jamaluddin. We'll present the first question in this presentation. So, the first question is, describe the appointment of a liquidator under Companies Act 2016. Now, let's take a look at the answer. First of all, we have to know what is liquidator. A liquidator is an independent and qualified person to investigate the affairs of the company during the process of winding up. According to the new Act, which is Companies Act 2016, any person who is a member of a recognized professional body may apply to the Minister of Finance to be approved as a liquidator. The general requirement for the appointment of a liquidator are provided under Section 433, subsection 3, that states, any person who is a member of a recognized professional body may apply to the minister charged with the responsibility for finance to be approved as a liquidator. Then, the qualified for an appointment as an interim liquidator or liquidator of a company according to Section 433, subsection 1. First, he is not an approved liquidator. Second, he is indebted to the company or to corporation that is deemed to be related to the company by virtue of Section 7 in an amount exceeding RM25,000. Third, he is an officer of the company. Fourth, he is a partner, employer or employee of an officer of the company. Fifth, he is a partner or employee of an officer of the company. Sixth, he assigns his estate for the benefit of his creditors or has made an arrangement with his creditors under any law relating to bankruptcy. And last, if he becomes bankrupt or if he is convicted of an offense involving fraud or dishonesty punishable or conviction by imprisonment for 3 months or more. Next, in Section 433, subsection 4, the minister charged with the responsibility for finance may approve such person as a liquidator if he is satisfied with experience and capacity of the person and upon payment of the prescribed fee by such person. Okay, now let's moving on to the appointment of liquidator in a member's voluntary winding up. According to Section 445, subsection 1, in a member's voluntary winding up, the company shall appoint one or more liquidators for the purpose of winding up the company's affairs and distributing its assets in general meeting. Section 445, subsection 2, on the appointment of a liquidator, all the powers of the directors cease except so far as the company in general meeting with consent of the liquidator or the liquidator sanctions the continuance of all the powers of the directors. Next, appointment of liquidator by court. In Section 453, subsection 1, where there is no liquidator acting in a voluntary winding up, the court may, on application, appoint a liquidator. Next, liquidators in creditors voluntary winding up. In section 450 subsection 1, the company shall and the creditors may at their respective meetings nominate a person to be a liquidator for the purpose of winding up the affairs and distributing the assets of the company. In subsection 2, if the creditors and the company nominate different person, the person nominated by the creditors shall be liquidator, and if no person is nominated by the creditors, the person nominated by company shall be a liquidator. Then, in subsection 3, notwithstanding subsections 1 and 2, where different persons are nominated, any director, member or creditor may apply to the court for an order directing that the person nominated as liquidator by the company shall be liquidator or jointly with the person nominated by the creditors within 7 days from the date on which the nomination was made by the creditors. For subsection 4, in section 450, the liquidator may, or if requested by any creditor or contributory shall, summon separate meetings of the creditors and contributors for the purpose of determining whether or not the laws of Malaysia 412 Act 777, creditors or contributories require the appointment of a committee of inspection as provided in 10th schedule to act with the liquidator, and if so, who are to be members of the committee. In section 5, the committee of inspection, or if there is no such committee, the creditors may fix the remuneration to be paid to the liquidator. For subsection 6, on the appointment of a liquidator, all the powers of the directors shall cease, except if the continuance of the powers is approved by the Committee of Inspection, or if there is no such committee, the creditors. And for the last, in subsection 7, if a liquidator other than a liquidator appointed by or by the direction of the court dies, resigns or otherwise vacates the office, the creditors may fill the vacancy, and for such purpose a meeting of the creditors may be summoned by any two of the creditors.
Second question. Discuss 12 grounds as the circumstance for the compulsory winding up. Hello to all my fellow friends and my lecturers seperti My name is Nur Masrina binti Muhammad Azmi from the 83A. My notice number is 01D820F1029. Today I will be presenting 12 reasons why company may be winding up under section 465. The first reason why company have to wind it up, the company has special resolution resolve. The company have to wind it up by the court. That means the company get a resolution by the court. They must to be winding up. The second reason is a company default a lodge statutory declaration under section 190 subsection 3. In section 190 subsection 3, it's mentioned the company shall lodge with registrar statutory declaration by a secretary or one of director of a company. The third reason is company does not commence a business within a year from its corporation. In other words, the company suspend their business for a whole year. For the fourth reason is the company doesn't have a member. As we know, the company need at least 2 members to incorporate the company. The first reason may be company winding up. A company is in insolvent situation, which is the company unable to pay their debt. For the sixth reason is the director act in other manner, which is the director being unfair to the member of a company. For the seventh reason is a company is expired, which is a fixed duration of company in constitution come to the ends. The next reason of company may be winding up is the opinion by the court the company has to be winding up in some situation. The first situation is a substratum which the company has no longer achieved their main objective. The example case is Piri versus Stewart, where the company shipping lost their only ship. The second situation is the management carried in such a way the minority that disregarded. The example case is Ibrahimi versus Westbourne Galleries Limited and Oz, where the Ibrahimi made a petition to be winding up. The next example for the second situation is that there are deadlock in management where no progress can be made. The example case is Yenis Tobacco Co Limited, where the two shareholders doesn't have any communication after dispute happened and only through the secretary. Next, for the third situation is a company formed to carry out fraudulent or illegal business. The example case is Brinsmith, Thomas Edward and Sons, where the company is a piano maker, but at the same time there are three workers set up another company to manufacture and selling the pianos. Next, for the ninth reason is the license under Financial Survey Act 2013 or Islamic Financial Survey Act 2013 is being cancelled or being surrendered. Next, for the 10th reason is a company carried license business without being a duly licensed. That means the license doesn't have a validity. Next, for the 11th reason is the company is being used for the unlawful purpose. That means a company is good for the bad intention. Next, for the 12th reason, which is the last reason, is the minister declaration under section 590. Under section 590, the minister will declaration after investing and affair of a company. That's all for my presentation about 12th reason the company may be winding up. Next question will be presenting by the Nur Shafisa. Thank you.
Hi, my name Nur Shafisa Tijaluddin. I as player 3 in this game will present about question number 3. Okay, let's look at the question. So, what do you think about the answer? Alright, let's look at the answer based on the situation. First, Matt accountant advised his to register private limited company. The reason is because to avoid Matt from liable the debt for potential loss. It is about separate legal entity according to section 20 in Companies Act 2016. The company as artificial person have own debt or asset, so the debt of the company will be not liable by the members because of the separate legal entity. Second, this case is about members voluntary winding up according to section 432 subsection 2 subsection A in Company Act 2016. Why I'm saying like that? It is because the shareholders and Matt, who is director for that company, want to winding up because they don't want to run up any more debts. It means the company is solvent because board meeting evaluation said the company still be able to pay the remaining debt balance. So from that, the company director, which is Matt, have to follow procedures of dissolved company by members voluntarily winding up according to section 432 subsection 2 subsection A. The procedure of member voluntary winding up, the majority of the directors have to make a written declaration of solvency stating the ability of the company to settle its debts within a period of 12 months after the commencement of the winding up process. After such declaration has been made, the company must then lodge the said declaration with the Registrar of Companies before the notice of general meeting is sent to the members, informing the intention to wind up the company. The date of commencement of the member voluntary winding up shall be the passing of the members' resolution to initiate the member voluntary winding up. The members' resolution must be passed within 5 weeks after the making of the declaration of solvency by the directors. A liquidator will be appointed by the members at the members' meeting. If the liquidator is of the opinion that the company will not be able to pay or provide for the payment of its debt in full within 12 months, the liquidator shall immediately call for a meeting of the creditors. Liquidator shall submit before the meeting a statement of the assets and liabilities of the company. The creditors may then appoint the liquidator appointed by the company or any other person to be the liquidator. As from the date of the creditors' meeting, the winding up becomes the credit voluntary winding up. This procedure is according to Companies Act 2016. That's all from us. Thank you for your time to listen our presentation. We hope you enjoy with the presentation. If you have any question, you can email us in Gmail as shown in this video. Bye!
Fly me to the moon and let me play among the stars. Let me see what spring is like on Jupiter and Mars. In other